Thank you, Honorable President. Honorable President, this is a public sitting of the court in the matter of Alfred Agbesi Woyome versus the Republic of Ghana, application number 001 of 2017. Honorable President, the two parties are represented by their counsel. Thank you, sir.
Thank you, Dr. Eno. Please, counsel, identify yourself before this court, starting by the applicant.
Honorable Justices, I am lead counsel for the applicant. My name is Kweku Osafu Boabing. The Osafu Boabing is compound, so there's a hyphen between Osafu and the Boabing. Yes.
You have not introduced your colleague?
Oh. And I'm with Reynolds Chumesi for the applicant. Reynolds Chumesi. Yeah.
Okay, thank you. Yeah. Respond.
My lords and my lady justices. My lords and my lady justices, I am Godfred Yeboah Dami, Deputy Attorney General of Ghana, representing the respondent. With me are Mrs. Dorothy Afriye Ansa, the Chief State Attorney, Mrs. Stella Bedu, also Chief State Attorney. Indeed, we bring you warm greetings from the Republic of Ghana to the President and the people of Ghana. Delighted to be here.
Thank you, counsels. You have received the program. So you have just, for this first round of oral submissions, 1 hour each. So we start with the applicant. Please, counsel, present your case.
Honorable Justices, the case of the applicant is that his rights under the combined effect of Articles 2, 3, and 7 of the African Charter, or the Banjul Charter, have been violated by the decision, the review decision of the Ghanaian Supreme Court delivered on the 29th of July, the year 2014. The background of this decision was a suit filed in the Supreme Court by an individual who used to be the Attorney General of Ghana for an interpretation that 2 stadia contracts were unconstitutional because the government had not sought the prior approval of Parliament under Article 181 Clause 5 of the Ghanaian Constitution. The ordinary bench of the Ghanaian Supreme Court, composed of 9 judges, in respect of the applicant, dismissed the case against the applicant, and primarily the reason was that there was already pending before the High Court an action filed by the Attorney General against the applicant, and the issues that were set down for determination by the High Court included whether or not the applicant was entitled to the amount of money that he had been paid by the government. Also, another issue was whether or not the applicant had a contract with the government to warrant the payment of the amount. The Ghanaian Supreme Court ordinary bench was of the view that the High Court was the proper forum and not the Supreme Court, because the Supreme Court's duty was to interpret certain provisions of the Constitution, and that's it. In that judgment, there were 2 concurring opinions. The lead judgment was written by Justice Dateba, and then there were 2 concurring opinions. Now, one of the concurring opinions was by Justice Doche. And Justice Doche, in his concurring opinion, agreed that the Supreme Court had no jurisdiction, but rather the High Court, to determine the case against the applicant. But he didn't end there. He made comments to the effect that the applicant had no contract with the government, and the applicant was not entitled to the amount of money that had been paid to him earlier on, pursuant to the action brought by the applicant against the government. In fact, he indicated in his concurring opinion that the applicant had formed an alliance with another party called Waterville to, if I may quote him, to create, loot, and share the resources of the Republic of Ghana. He again referred to the applicant as being at the center of, quote, the infamous Woyome payment scandal. The concurring opinion did not end there. He also indicated that if the lawyer for the applicant at that time had closely examined the documents available to him, he would have realized that the applicant had absolutely no claim against the government. That was his concurring opinion. We have exhibited all these judgments in our submissions. Subsequently, the plaintiff in that case, at the ordinary bench, dissatisfied with that part of the judgment, applied for a review under Article 133 of the Ghanaian Constitution. The panel consisted of 8 of the judges who were on the ordinary bench. One was not present because at that time, the judge who wrote the lead judgment of the ordinary bench, Justice Datiba, had retired because he was 70 years. That's a requirement in Ghana. If you are 70 years, you have to go on retirement. So he had retired. And therefore, 3 new judges, 3 judges were added to the panel to make it 11. Now, the judgment of the review decision of the review court, of the Supreme Court, was written by this same Justice Doche. Now, with that mindset created in the concurring opinion, Justice Doche, in his lead judgment, this time granted the reliefs of the plaintiff and held that and ordered that the applicant should refund the monies that were paid to him earlier on by a court judgment to the states. Indeed, if you look at the ordinary bench decision and you look at the review bench decision, both courts agreed that the High Court was the proper forum. The only difference this time is that after agreeing that the High Court was the proper forum to hear the matter, the review court or the lead judgment indicated that there was a danger that if they allow the High Court to hear the matter on the merits to its conclusion, they would come out with a different results. Comments were made by the lead judgment, or were made in the lead judgment, and as a result, the lead judgment indicated that the applicant was linked to the stadia contracts, and therefore he should refund the money to the state. Again, the lead judgment indicated that even though the matter was pending before the High Court, the Supreme Court could not guarantee that to predict the outcome of the matter in the High Court. Again, the Supreme Court, in the review decision, indicated that if their decision should affect other cases involving the applicant in the High Court, to quote, "so be it." Now, this was at a time that the applicant, in addition to the civil case pending in the High Court, was facing criminal prosecution. He was facing 2 charges of defrauding the state of Ghana and causing financial loss to the state. In that judgment, the review bench indicated that the tendency where state resources are allowed to be dissipated must be brought to an end. The contention of the applicant is that flowing from the earlier concurring opinion to the decision of the review bench, the court cannot be said to have been impartial. I say so because the issue that came before the Supreme Court was simply constitutional interpretation. So, with all respect, for the learned judge to go beyond the constitutional interpretation and then decide that the applicant had no contract with the government, and therefore the applicant had no case, and that the applicant had formed an alliance to create, loot, and share, was beyond what was before the business of the Supreme Court. And he had formed that prejudiced mind. No wonder, within a few weeks, he wrote the lead judgment for the review bench of the Ghana Supreme Court. Now, the ordinary bench decision was on the 14th of June, 2014. The review bench decision was on the 29th of July, 2014. The learned judge had indicated, with all respect again, his disdain for the applicant. And it is no wonder that the review, he wrote the lead judgment of the court. And if you read the lead judgment of the court on the review and link it to his concurring opinion, the comments made in his concurring opinion in the ordinary bench decision, who contend that the applicant was not given a fair trial. Now, under Article 12 of the Ghana Constitution, issues bordering on human rights, and in this instance, a fair trial, impartiality, are to be observed not only by the executive or legislature, but by the judiciary as well. Article 12 of the Ghana Constitution, that not only it is the executive, the legislature, and the judiciary that must uphold and observe fundamental human rights. So, the Supreme Court, with respect, cannot, in our contention, be said to have upheld the right of the applicant to a fair trial and was not impartial. In effect, the Supreme Court truncated the matter, civil matter that was pending before the High Court, even though the jurisdiction that had been invoked by the plaintiff in the constitutional matter was purely for constitutional interpretation. The Supreme Court admittedly has supervisory jurisdiction over the High Courts, but to invoke the supervisory jurisdiction of the Supreme Court, there is a specialized procedure. The Supreme Court's supervisory jurisdiction had not been invoked. And by truncating the High Court matter, the applicant did not have the opportunity to put his case across on the merits of the claim. Our contention is that if a judge of the Supreme Court describes the applicant in a matter that has come before him for constitutional interpretation as, quote, creating, looting, and sharing, subsequently involving the applicant in the same matter, definitely, with respect, his mind will be prejudiced. And it is as a result of this that we are contending that the applicant's rights under Articles 2, 3, and 7